The deed was filed on a Tuesday in June, 3 months and 11 days after Margaret Ellison was buried in Clayton County. Her signature was on the document. The notary stamp was current. The transfer looked, to anyone reading the public record, like a routine property conveyance. An elderly woman selling her home to a private company called Palmore Capital Group before she died. What it was a forgery on a dead woman's name. Margaret's sister Frances found out in September when she went to the house to finish clearing the estate and found a contractor's truck in the driveway and new locks on every door. The locked garden shed behind the house had not been touched. Nobody from Palmore had found the key. Frances had it on her keyring, where Margaret had put it the last Christmas they spent together, and she had said, "If anything ever happens to me, go to the shed first." In 2022, in Clayton County, Georgia, a 73-year-old woman's home was stolen through a forged deed filed 3 months after her death, transferring her property to a private real estate company whose representatives had begun renovating the house before the family discovered what had happened. This is her story, with details changed to protect her privacy. Margaret Ellison had lived on Wisteria Drive in Morrow since 1994. She had bought the house alone, at 45, after a divorce that she had handled with the same practical composure she brought to everything. Sorted the finances, signed the papers, found the house, moved in. It was a 3-bedroom ranch on a corner lot, with a deep backyard and a detached garden shed that the previous owner had built from cedar, and which Margaret had claimed immediately and completely. She was a gardener, the way some people are readers. Seriously, consistently, with accumulating knowledge and a genuine preference for the company of growing things over most other company available to her. She had taught middle school science in Clayton County for 26 years, retiring in 2018. She had 2 grown children, a son named Carl, who lived in Charlotte, and a daughter named Diane, who lived in Phoenix, and a younger sister named Frances, who lived in Decatur, 20 minutes away, and who came for Sunday dinner most weeks and was the person Margaret called first about everything. Frances was 68, sharp, and had worked as a paralegal for a real estate attorney in DeKalb County for 19 years before retiring in 2020. This fact would matter. Margaret had been diagnosed with congestive heart failure in the fall of 2021. The prognosis was measured, her cardiologist having used the word manageable in the initial consultation, and then revised his language over the following months as the condition progressed faster than the initial assessment had suggested. Margaret managed it with the same composure she brought to everything else. She updated her will in January of 2022. The house to be divided equally between Carl and Diane, Frances named as executor. She gave Frances a key to the garden shed that Christmas, pressing it into her hand at the door when Frances was leaving after dinner, and saying what she said about it. Frances had asked what was in the shed. Margaret had said, "Everything that matters. You'll know what to do with it." Margaret died on March 4th, 2022, at home, with Frances beside her. She was 73. Carl and Diane flew in for the funeral. The estate process began in the ordinary way. Frances filed the will with the Clayton County Probate Court in April. The court issued letters testamentary, and Frances began the methodical work of settling a life, notifying institutions, cataloging assets, arranging for the house to be cleared before it was listed for sale. She had done this kind of work professionally. She knew the steps. On June 15th, 2022, a deed was recorded with the Clayton County Superior Court Clerk's Office, transferring the Wisteria Drive property from Margaret Ellison to an entity called Palmore Capital Group, LLC. The deed bore Margaret's signature, notarized by a man named Curtis Fenn, with a notarization date of February 28, 2022, 4 days before Margaret died. The transfer price listed on the deed was $41,000. The house had been appraised at $187,000 the previous year. Frances did not know the deed had been filed. The probate court, which was processing the estate in the ordinary queue, had not yet run a title search that would have flagged the competing conveyance. Palmore Capital Group had obtained a deed, recorded it, and proceeded on the assumption that the filing constituted ownership. By August, they had a contractor working on the property. By September, when Francis drove to Wisteria Drive with a rented trailer to finish clearing Margaret's belongings, the locks had been changed and the contractor's truck was in the driveway, and a man Francis did not recognize opened the front door and told her the property had been sold. Francis stood on the porch of her sister's house and looked at the man for a long moment. Then she said, "I am the executor of Margaret Ellison's estate, and my sister did not sell this house." Then she walked to the backyard, unlocked the garden shed, and went inside. The garden shed was 12 feet by 14, cedar-sided, with a pitched roof and two windows that Margaret had fitted with simple wooden shutters, painted the same dark green as the house trim. The interior smelled of potting soil and cedar and the particular mineral dryness of a space that has been closed through a summer. Frances pulled the string on the overhead bulb and stood for a moment, letting her eyes adjust. Margaret had used the shed the way she used everything, with system and intention. Along the left wall, a potting bench ran the full length, its surface clean. The tools hung above it on a pegboard. In the outlines, Margaret had traced in marker, so everything returned to its correct place. Clay pots were stacked by size on shelves below the bench. Bags of soil amendment were lined up on the floor beneath the shelves, clipped closed with binder clips. Along the right wall, a metal storage unit held labeled bins, bulbs, seeds, netting, stakes, organized by season of use. At the back of the shed behind the storage unit was a section Frances had not seen before. Margaret had built, or had someone build, a simple plywood cabinet against the back wall, floor to ceiling, with two doors that closed with a small sliding bolt. It was not locked. It was simply closed, and set back enough from the shed entrance that a person looking in from the door would not immediately see it. Frances opened it. The cabinet held 4 shelves. The top shelf held a fireproof document box, dark gray metal, combination lock, and a sealed envelope with Frances's name on it in Margaret's handwriting. The second shelf held a row of 3-ring binders, each labeled on the spine: property, finances, insurance, medical, personal. The third shelf held a portable hard drive in a padded case, a notepad with a list of account numbers and passwords in Margaret's hand, and a manila envelope labeled Photographs, House, Current, with a date, January 15th, 2022. The fourth shelf held 2 items: a bundle of letters tied with kitchen twine and a smaller envelope labeled For Probate Attorney. Open immediately if house is disputed. Frances took the smaller envelope first. Inside was a single page in Margaret's handwriting, dated January 12th, 2022, 3 days before the photograph envelope. It read, Frances, if you are reading this because someone is claiming the house was sold or transferred, it was not. I have never spoken to any buyer. I have never signed any transfer document. If a signature exists on a deed, it is not mine. I am writing this and dating it while I am fully competent and of sound mind to say clearly, I did not sell this house, and I did not intend to. The house goes to Carl and Diane, as stated in my will. The photographs in the January envelope show the house as it was, on January 15th, 2022, taken by me, time-stamped on the camera. The camera is in the kitchen drawer to the left of the stove. The memory card has not been removed. Frances sat down on the potting bench stool and read the page twice. Margaret had known. Not that it would happen, but that it could happen. That properties like hers, paid off and modest, and belonging to an aging woman without a husband, were the kind of properties that attracted certain kinds of attention, and that the right preparation might matter. She had been a science teacher for 26 years. She had understood evidence. The combination to the fireproof box was Margaret's retirement year, 2018. Inside were the original deed of purchase from 1994, the property tax records current through 2021, and a document Frances recognized from her paralegal years, a previously recorded affidavit of survivorship filed with the Clayton County clerk in 2019, in which Margaret had formally declared sole ownership and unencumbered title to the Wisteria Drive property. Also in the box, a copy of the updated will and a card for a Decatur attorney named Patricia Osei, who specialized in real estate fraud. Frances called Patricia Osei from the garden shed, seated on the potting stool, with the shed door open to the September afternoon and the sound of the contractor's tools coming from inside the house. Patricia Osei had handled 11 deed fraud cases in the Atlanta metro area in the preceding 4 years, a number that reflected a regional pattern she had been tracking since 2019, when predatory deed transfer schemes targeting paid-off properties in Clayton, DeKalb, and Fulton counties had begun appearing in the probate court filings she reviewed. She knew what Frances was describing before Frances finished describing it. She said, "Bring me everything in that shed. Come tomorrow morning." The legal foundation of the case rested on a principle that Patricia explained to Frances and Carl, who had flown back from Charlotte, at their first meeting. A deed executed by a person who was deceased at the time of execution is void on its face. The notarization date on the Palmore deed was February 28, 2022. Margaret had died on March 4th. This appeared at first reading to create a narrow window in which the deed could have been legitimate. Margaret had still been alive on February 28th. But Margaret's letter from the shed, dated January 12th, and stating unambiguously that she had not sold the house and had not spoken to any buyer, directly contradicted any claim of a legitimate February transaction. Combined with the medical records from Margaret's cardiology team, showing that she had been on continuous oxygen support and largely unresponsive in the final week of February, records Frances obtained from the treating physician with authorization under the estate, the timeline became clear. Margaret could not have signed anything on February 28th. She had not been capable of signing anything on February 28th. The notary, Curtis Fenn, operated a mobile notary service out of a van registered in Fulton County. Patricia filed a complaint with the Georgia Superior Court Clerks Cooperative Authority, which oversees notarial records, and separately obtained Fenn's notarial journal through a records request. Georgia law requires notaries to maintain a journal of every notarization, including the signer's identification and the date and location of signing. Fenn's journal entry for February 28th listed the signing location as the Wisteria Drive property. Margaret's medical records placed her at a Clayton County cardiac care facility on that date, where she had been admitted 4 days earlier. She had not been on Wisteria Drive on February 28th. Fenn had not met Margaret on February 28th. He had notarized a document bearing a dead woman's forged signature and logged a location that was demonstrably false. Patricia filed an emergency motion in Clayton County Superior Court in October of 2022, seeking an immediate injunction against any further action by Palmore Capital Group on the property and a Elias Pendens against the title. The motion was granted within 72 hours. The contractor left the property the following day. Palmore's renovation work, they had replaced the kitchen fixtures, torn out the original bathroom tile, and begun work on the back bedroom, stopped where it stood. Frances had gone to the Clayton County Police Department in September before she contacted Patricia and had been told by a detective at the front desk that deed disputes were civil matters and that she should consult an attorney. This was not accurate. Deed fraud in Georgia constitutes forgery in the first degree under OCGA Section 16-9-1, a felony, and filing a forged document with a county court constitutes a separate offense under Section 16-9-4. Patricia documented the police department's refusal in a letter she sent simultaneously to the Clayton County DA's office, the Georgia Attorney General's Consumer Protection Division, and the Georgia Real Estate Fraud Prevention and Awareness Coalition, a nonprofit that tracked deed fraud cases across the state and maintained relationships with prosecutors willing to pursue them. The DA's office opened a criminal investigation in November of 2022. The Attorney General's office opened a parallel consumer fraud investigation into Palmore Capital Group's acquisition practices, which, the AG's investigators found, had followed a consistent pattern across 9 properties in Clayton and Henry counties over 3 years. The civil confrontation came at a hearing in December of 2022. Palmore's attorney, a real estate litigator from a Buckhead firm, argued that his client had purchased the property in good faith, had recorded a valid deed, and had invested in improvements that constituted a financial interest the court was obligated to protect. Patricia stood and presented three things: Margaret's handwritten letter from the garden shed, the medical records placing Margaret at the cardiac facility on February 28th, and a side-by-side handwriting comparison prepared by a forensic document examiner showing that the signature on the Palmore deed bore no meaningful resemblance to Margaret's actual signature on the 1994 purchase deed, the 2022 will, or the 2019 affidavit. She said the good faith purchase doctrine does not extend to a buyer who acquires property through a void deed, because a void deed conveys nothing. There is no title to purchase in good faith when the instrument of transfer never legally existed. Judge Raymond Hollis voided the Palmore deed in January of 2023. The corrective deed restoring title to the estate of Margaret Ellison was recorded with the Clayton County Superior Court clerk on January 19, 2023. Curtis Fenn surrendered his notarial commission in February, under an agreement with the Georgia Secretary of State's office. Palmore Capital Group's principal, a man named Terrence Mobley, 44, operating the company out of a registered address in College Park, was indicted by the Clayton County Grand Jury in March of 2023 on 2 counts of forgery in the first degree and 1 count of filing a false document. Fenn was separately indicted on the same charges. Both cases were pending trial as of the estate's settlement. The renovation damage, the stripped kitchen, the demolished bathroom tile, the incomplete back bedroom, was assessed at $23,400 in a contractor's report Patricia commissioned. She filed a civil claim for that amount against Palmore as a separate action, which settled for $21,000 in April of 2023 before the criminal trial. Frances locked the garden shed on her way out after the January hearing. She put the key back on her keyring. She did not know yet what she would do with the shed's contents: Margaret's tools, the labeled bins, the plywood cabinet with its 4 shelves of careful preparation. She thought she would leave them for a while. It seemed right, given what they had done. The Wisteria Drive property sold on April 14, 2023, for $204,000, $17,000 above the 2021 appraisal, reflecting both the market and the restored clear title that Patricia had ensured was properly documented in the chain of title going back to 1994. The sale closed at a title company in Morrow on a Tuesday morning with Carl and Diane present, and Frances as executor, signing the final documents. Patricia attended. After the closing, they went to a diner on Terra Boulevard that Margaret had liked and ordered lunch, and Frances told Carl and Diane about the garden shed, about Margaret's letter, the photographs, the envelope labeled "For Probate Attorney," the evidence their mother had assembled quietly in January, while she was still capable of assembling it. Carl said, "She always did the reading before the test." Diane didn't say anything for a moment. Then she said, "Yes, she really did." The estate distributed $204,000 in sale proceeds, plus Margaret's remaining accounts: a checking account, a small IRA, and a savings account that brought the total estate to $271,000, equally between Carl and Diane, as the will directed. The $21,000 settlement from Palmore's renovation damage claim was applied first to estate expenses, with the remainder distributed in the same proportion. Frances donated $8,000 in Margaret's name to the Georgia Real Estate Fraud Prevention and Awareness Coalition, whose work had contributed to the criminal investigation. She also contacted the Clayton County Police Department, not to complain, though the complaint was documented in the AG's file, but to speak with the department's community liaison officer about the specific gap she had encountered at the front desk in September 2022, when a detective had turned away a family member reporting a deed forgery as a civil matter. She brought Patricia's one-page summary of the relevant Georgia criminal statutes. The liaison officer told her the department was revising its intake protocol for property fraud reports. She said she was glad to hear it and left a copy of the statute summary on his desk. The garden shed was sold with the house. Francis had emptied it before closing, taken the tools, the bins, the binders, the fireproof box, the camera with the memory card still inside. The plywood cabinet she had a handyman disassemble carefully and store flat in her garage in Decatur. She was not entirely sure what she would do with it. It was just cedar and plywood and 4 shelves. But Margaret had built it or had it built, had stocked it with the specific materials that a dispute would require, had sealed an envelope and written a name on it and put it exactly where it needed to be. Frances thought that deserved some consideration before she put it at the curb. She planted Margaret's spring bulbs in her own garden in Decatur that October, the dahlias and the alliums, and the dozen varieties of tulips she found in the labeled bin, each packet annotated in Margaret's handwriting with the planting depth and the expected bloom week. She planted them in the bed along the south fence, where the light was similar to Margaret's backyard on Wisteria Drive. Most of them came up in April. The dahlias were extraordinary. On a Sunday morning in April of 2023, 6 weeks after the corrective deed was recorded and 3 weeks before the house sold, Frances drove to Wisteria Drive one last time and sat in her car in front of the house for a few minutes. The contractor's damage had been repaired, the kitchen refitted, the bathroom retiled, by a crew Carl had hired in February. The dark green shutters on the garden shed were visible above the fence line. The corner lot maple was starting to leaf out, pale green against the April sky, the same maple that had been there since before Margaret bought the house and would be there long after. Frances started the car and drove home. The key to the garden shed was on her keyring. She thought it could stay there.